Good afternoon and welcome to the Appellate Division First Department. Most of you who have been here before know the drill. I will call the calendar. Please tell me the time you need for your argument, not the time that you want. Please understand that the light of time is for you, not for the court. So if my colleagues have additional questions, I will not interfere with that, okay? All right. And I left my glasses upstairs. Okay, not a good start. No, it's okay, I'll figure it out. Okay, People versus Raul Ayala. Okay. 4 and 1 and 3. Reparthy versus Clark.
Good afternoon, Your Honors. Defendant appellate informed me this week that they intend to submit on papers. We're prepared to proceed on papers.
Okay, so submitted and thank you. Please wait until the end of the call of the calendar. All right. Alavi versus Hertz. The court heard from, go ahead. Oh, I didn't realize there would be someone here.
Well, yes, I'm here as a courtesy. I understand this morning there was going to be submission of both cases by the appellant. I would request 5 minutes for both cases.
No. I'm sorry, I'm not going to do that. I will give you 3 minutes to argue and highlight any points you wish to highlight. Okay? All right. People versus David Hernandez.
On behalf of the appellant, 6 and 2, Your Honor.
Okay? 5 and 1 and 5. Again, if the panel has more questions, I will not interfere with the court, okay? Carson versus JAD Realty. Submitted. Oh, I'm sorry. Forgive me. You got it. I'll give you 3. How about that? All right. People versus Malakim Hurt. Okay. 5 and 1 and 5. Again, I won't stop my colleagues. People versus Marquise Garrett is submitted. Mazzone versus Alonzo et al. Okay. Okay. I'm sorry, how much time?
7 minutes.
Okay. Okay, you guys have asked for entirely too much time. So 6, 2, 6, and 6. And if we need more time, my colleagues will let me know by their questions. All right. First case on the calendar, People versus Raul Ayala.
Step up.
Could you? Thanks. You may proceed, sir.
May it please the court, Samuel Steinbach Pratt from the Office of the Appellate Defender on behalf of Raul Ayala. Respondent has conceded that this case needs to be remitted for Supreme Court to consider the YO issue in the first instance. So unless the court has any questions, I'm only going to address our second point about the jurisdictional sufficiency of the indictment on the weapons count.
I think that's wise. Go ahead.
The CPL provides that a juvenile like Mr. Ayala may not be indicted or prosecuted for second-degree criminal possession of a weapon unless the firearm is possessed on school grounds. Because the school grounds requirement is a prerequisite to prosecution, it must be alleged in the indictment, and the absence here is a jurisdictional deficiency. There are several textual clues to this. First, in commanding that the grand jury not indict juvenile for criminal possession of a weapon unless the school grounds requirement is met.
Well, counsel, I think that your adversary in their papers, and I believe, in their papers in their argument, is that that particular statement on school grounds is not included in the actual statute. It's included in a separate statute. And given that, they're stating that, therefore, it is not an element of the crime. So can you address that?
Of course, Your Honor. I agree that for most cases that would be true. I think what we have here is an unusual provision. CPL 19071 doesn't just say, you may not be convicted or you must be acquitted if this is ultimately proven not to be the case. It's not just a defense at trial. It's a limitation on the grand jury's power to indict in the first instance. It specifically says the grand jury must not indict a juvenile for this offense unless the weapon is possessed on school grounds. Given that, the CPL clearly contemplates a finding by the grand jury that the weapon was possessed on school grounds and that it has to be alleged in the indictment. Otherwise, the charge just is facially insufficient.
So why can't the defendant, after an indictment, simply come back and say, as an affirmative defense or affirmatively, it wasn't on school grounds?
Well, I think because exactly the issue that it isn't just a defense to prosecution like most affirmative defenses. The way it's written is as an affirmative grant of prosecutorial authority under limited circumstances. It's not written the way that a lot of other defenses, would be. Instead, it's phrased as they may indict under these limited circumstances. I don't think there's any way to make sense of that provision unless the grand jury has to make a finding and put it in the indictment to prove that they have the authority in the first instance. I think analogously, felony murder, a juvenile can only be indicted or prosecuted for, where they would also be criminally responsible for the underlying felony. If an indictment alleged felony murder based on a non-qualifying felony, it would obviously be facially deficient. It would be very clear that the juvenile could not be.
But wouldn't that be included, your example in terms of felony murder, isn't that included in the statute? Does it not also state and in the commission of a felony?
Well, but the specific underlying felony needs to be one for which the juvenile is criminally responsible, and that comes from CPL 19071, just like the school grounds requirement. There are just circumstances, and they're rare. It's unusual the way it's written for criminal possession of a weapon. Most of the qualifying offenses for JOs.
So if you look at People v. is it Kohut? I think it's Kohut, right? If you look at that case, which I recognize, I think that was in the 70s. But under that case, doesn't it state that because it's outside of the statute, then therefore it becomes an affirmative defense?
I think that's true in the mine run of cases. I think, again, what makes this statute unusual is that it's not written as a defense to conviction, but as a limitation on the grand jury's power to indict. The grand jury doesn't say you can't indict someone if they were justified. The CPL doesn't phrase it in that way. But here, there are multiple provisions that address when a juvenile can be charged with CPW2, but there is one specifically that says the grand jury can't indict you unless this is met. And I think that's crucial to understanding how this works and what it functions as a limitation on the power of the grand jury to indict unless this foundational finding is made. And that being the case, it doesn't make any sense to leave it out of the indictment and leave it to leave out this crucial jurisdictional.
So what effect, if any, is had on considering the fact that the on-school grounds was submitted to the grand jury, and two, that the defendant pled guilty and admitted to the on-school grounds portion?
I'm going to take that in reverse order, if that's all right, Your Honor. Obviously, an allocution at the time of a plea couldn't cure a jurisdictional deficiency in the indictment, so if you accept our argument that it needs to be alleged in the indictment, the allocution is largely irrelevant. I'll also note that he doesn't actually allocute to being on school grounds. He allocutes to being within 1,000 feet of a school, which is only one half of the school grounds definition.
And it was an answer yes to the prosecutor's colloquy of what happened, correct?
That he was within 1,000 feet of a school,
Right.
Yes, but again, that's only one part of the definition of school grounds. As to what was submitted to the grand jury, we don't have the grand jury minutes, I can't speak to that specifically, but assuming it was, it still wouldn't cure the failure to allege it in the indictment, just as submitting evidence of an element wouldn't cure a failure to submit the element in the indictment.
Why doesn't the analysis in People versus Santana present a problem to you in which the Court of Appeals said it depends on whether it's in the statute defining the crime or not as to whether, as to how it gets treated?
Again, I think that's true in the vast majority of cases, Your Honor, but I don't think it makes any sense to use the so-called exception proviso distinction here. The reason being that it is phrased as a limitation on what the grand jury is permitted to do, which is quite unusual. Most statutes are not written that way. And that it's worded as an affirmative finding the grand jury must make. It doesn't say you're liable for criminal possession of a weapon unless it's not on school grounds. It says you're liable when it is on school grounds. That's something that has to be proven up by the prosecution in the grand jury, not negated by the defense. Thank you.
Thank you. You may proceed.
Thank you. May it please the court, Carrie Fulham for the people. The people concede that a remand is proper under issue 1, but the people submit that 2 counts should be before the sentencing court on remand. That is the count for attempted murder, as well as the count as charged in count 5 in the indictment for criminal possession of a weapon in the 2nd degree. And I'd like to just take a step back and set the analytical framework of the issue here, because there are really 2 analytical inquiries involved. The first is whether or not there's jurisdictional sufficiency in count 5 as alleged in the indictment. And defense argues that the language on school grounds is an element, not in most cases, but only in cases affecting youthful offenders or juvenile offenders. And as Justice Friedman just discussed with People v. Santana and Justice Weber before that, that is simply not supported by case law. Case law shows that where there is qualifying language in a separate statute that is not the statute that governs the crime, then that is not an element that must be alleged in the indictment. Rather, it is a
Also, if
proviso.
this case had gone to trial, would it have been the people's burden to prove that this happened on school grounds beyond a reasonable doubt?
Your Honor, no, and People v. Stokes says just that. People v. Stokes says that it is a defense to be raised by the defendant. Now, defendant also could have made a motion to dismiss the indictment. Certainly, there would have had to have been
Could you have had a conviction without any evidence that it happened on school grounds?
no. And
Then what's your burden?
so, just like any other defense, Your Honor, if the defendant would raise the argument saying this was not.
No, I don't understand that. Yeah,
Go ahead.
that's a conflict. You can't say the prosecution has to establish beyond a reasonable doubt that the crime happened on school grounds and then say, but it's not an element.
Well,
Those two don't connect.
Well, Your Honor, People v. Stokes says just that. And People v. Stokes says this is not, and certainly at the jurisdictional stage of the indictment, which of course is the stage concerned
But
here.
how would you get jurisdiction under the statute but for having to show that it was on school grounds? If it were not on school grounds and therefore this 15-year-old could not be prosecuted, it would be that he could not be prosecuted in Supreme Court and the case would have to be removed to family court. So don't you have to establish that jurisdiction in Supreme Court?
Yes, that's correct. Absolutely, there would have to be evidence brought forth by the people establishing possession on school grounds.
Wait, but her question was whether you would have to establish jurisdiction. You said yes. So do you have to establish jurisdiction just for some things and not for others? I don't understand that.
Justice Manzanet, CPL 200.20 subdivision 6 controls here. And that statute says it is not a jurisdictional infirmity to have one count charging a crime that defendant is criminally responsible for, as well as one count which on its face, defendant could not be criminally responsible for.
So what I don't understand also is that I'm looking at the indictment. This is I guess it's the amended indictment. Under count, what count it is? Count 2 of the indictment says the defendant in the county of New York, December 29, 2019, possessed a loaded firearm, a high-point semi-automatic, on school grounds with the intent to use it unlawfully against another. The 4th count of the indictment does not say on school grounds. The 4th count of the indictment possessed not being in the defendant's home or place of business, and said possession being on school grounds. So you have the 3rd count, the 4th count, both alleging on school grounds. And then you have the 5th count, which is the count that the defendant pled under, which does not include on school grounds. So my question to you is, why would you include on school grounds on certain counts and not include on school grounds on other counts if your argument is you didn't have to include on school grounds at all?
So 2 responses there, and I think this might clear up some confusion. The fifth count refers to the weapon possession found in defendant's home. And there was no gamesmanship by the people below. The people were not trying to suggest that his mother's home was somehow on school grounds. That is why that language on school grounds does not appear in count 5. Okay, the people's theory was that it was connected to, and ballistics testing confirmed that it was the same gun that was fired on school grounds. But getting back to your question, Justice Weber.
Wait, so can you get a conviction then on count 5 without showing that it was on school grounds?
Well, we can because of the plea allocution. And so I'm not suggesting at all, Your Honor, I see that
Continue.
Thank you. I'm not suggesting at all that this conviction could have stood without defendant admitting the necessary required information that his possession occurred
It
on
doesn't make
school
any
grounds.
sense. You're still talking about the sufficiency of the indictment and whether or not it is jurisdictionally sufficient. So I'm not understanding how we jump all the way to the allocution.
So
So
again,
you're saying that the allocution saves you, right? Because the defendant actually allocated, it saves you.
and that is completely supported by CPL 200.20 subdivision 6. The CPL expressly
So that
contemplates.
CPL section that you just cited, that says that if you screw up and if you don't allege the proper elements in the indictment, you're saved by a defendant pleading guilty to a jurisdictionally defective indictment.
Your Honor, the preface is there that it's an element. People versus Cohote and People versus Santana suggest that it's not an element because it operates outside of the governing
But what I
law.
still don't understand is you have to prove it. And I think you conceded that you have to prove that it was on school grounds. So if you have to prove something, why does it not become an element?
Your Honor, just under the case law that we have, again, that's Cohote, Santana, and
Yes, counsel, but an affirmative defense doesn't have to be disproven unless asserted. And you started your argument by suggesting that this was an affirmative defense that this infant defendant had to raise, right?
yes, Your Honor.
So I just don't understand the reasoning then.
And then Santana's 2006, is that before or after the raise the age and the statute?
I believe it would be before, Your Honor.
Santana would be before.
I believe. I don't know for sure, but I believe.
I think it was. I do believe it was.
But again, that defense language is not just people pulling it out of thin air. That comes from the Penal Law 30, Subdivision 4.
Do we look at the legislative intent? Because we're talking about raise the age and basically raise the age, right? And the implementation of this, of the statute. So do we look at the intent of the legislature at all in terms of prohibiting certain conduct or criminalizing certain conduct for individuals 13 to 15?
So the court could look at the legislative intent, but precedent under statutory construction says that's only required when there's an ambiguous statute. Here, that exception for criminally responsibility and youthful offenders does not appear at all within the governing statute 2605.
Also, I just want to make sure that I understand what you're saying. With regards to count 5, is it your position that if this case went to trial and the people did not put in any evidence that this happened on school grounds and the defendant did not raise the affirmative defense that it happened on school grounds, that you could lawfully get a conviction on a 15-year-old?
I think defendant would have a motion in that sense, Your Honor. I think defendant could challenge Justice Weber presented this issue, said in that case, I think the better recourse would bring it to family court for a fact-finding juvenile delinquency adjudication.
But if you're taking it to family court, that means that the Supreme Court didn't have jurisdiction. So we're back to it's like a circular argument.
And the thing that really saves the people here, I'm not overlooking this at all, is the fact that that required information, not an element, but required fact came out at his allocution. He admitted
An allocution where a 15-year-old was read a sentence by a prosecutor and he said yes.
Yes, Your Honor.
That's what we hang our hat on.
But again, you can't allocute to a jurisdictionally defective indictment. That's what, I mean, an allocution does not save the fact. You don't waive jurisdiction by pleading guilty to the indictment if it's defective.
CPL 220 subdivision 6 says that indictment, that count, can absolutely go forward. A court can have jurisdiction over that count as long as it's...
my question is, if it is jurisdictionally defective, a plea of guilty does not in any way, doesn't detract from the fact that it was defective. You can't waive jurisdiction.
Agreed, Your Honor. However, if it's not an element, and that really is
That's why
what's
Justice
underpinning.
Daniel said it's circular, because that's basically what you're saying, because you're saying that you're saved because of the allocution. But my point is, I don't think you are saved because of the allocution if, in fact, it is jurisdictionally defective, because then family court would have jurisdiction and not Supreme Court. So no allocution in Supreme Court would, quote-unquote, save you.
Thank you.
Thank you.
What was the section you were pointing to?
I'm sorry, Justice Friedman.
What section did you point to, CPL 200?
CPL 200.20, subdivision 6. Thank you.
Thank you. Counsel, you have 2 minutes.
Thank you, Your Honor. I'd like to just begin by saying I think respondent has now conceded that there was not sufficient evidence for Mr. Ayala to actually be convicted of this in the first place, and the fact that they're hanging their hat on his allocution, which did not establish that he was on school grounds as defined in the penal law regardless, I think says a lot. I'd like to touch briefly on what Justice Weber mentioned about what court this needs to be in. That's what we're talking about here, is whether it needs to be in Supreme Court or family court. And if you look at the legislative history of when this offense was added for juvenile offenders, that's actually in the bill jacket. A lot of what they were talking about was these cases need to be prosecuted in Supreme Court when it's on school grounds. But under respondent's rule, you could look at an indictment and have no idea which court it's supposed to be in. I mean, that just doesn't make any sense. If you put the school grounds allegation in the indictment, then you can look at it, and there's no confusion whatsoever about where this case is supposed to be.
Why doesn't CPL 200.20 subdivision 6 save the people's position?
Well, so we're not alleging that there was anything wrong with including an offense for which he could not be prosecuted as an adult, which I believe is the provision you're talking about, which says when you have some offenses which qualify for adult prosecution, you can also include juvenile offenses in the indictment. But the case law is very clear that Supreme Court does not have jurisdiction to accept a guilty plea to those counts in that case. I mean, there's extensive case law from the departments of the Appellate Division about that, and that's really what we're talking about here, is Supreme Court having jurisdiction to accept Mr. Ayala's guilty plea on this count of the indictment.
But you do concede that if the defendant had pled guilty under the other 2 counts, there would not be an issue?
Yes, because they allege the school grounds requirement. That's correct. And then I just very briefly want to mention that
But why isn't CPL 200.20 subdivision 6, why doesn't that mean to deal with the situation that we have here? Why doesn't our situation fall whether you have one crime which he's liable of regardless of the fact of infancy, so then you can charge another one which he wouldn't be liable because he's an infant?
So to be clear, Your Honor, we agree that that provision makes it okay to include this count in the indictment, just as
why do you need this to make it okay to include it in the indictment? The statutory scheme that we have makes him as a 15-year-old subject to this charge. So you don't need CPL 200.20 subdivision 6 to permit that, because the penal law otherwise makes it an indictable offense. I know we have this issue whether they had to mention the school grounds, but clearly that is something which could be in an indictment. So you don't need subdivision 6 for that.
Well, so this offense is one for which a juvenile may or may not lack criminal responsibility, depending on whether the gun is possessed on school grounds. So our view is that it can be properly included into the indictment as an offense for which the juvenile lacks criminal responsibility because there's no school grounds allegation. But that doesn't give Supreme Court jurisdiction to accept a guilty plea on that count.
On that ground. Thank you.
Thank you, Your Honors.
Alvey versus Hertz, you have 3 minutes.
Good afternoon, Your Honors. I'm Robert Douglas. I represent the appellant. I've been representing him for almost a decade, and I've been before this court before in this case. And because of the fact that it is on the original record, and because of the fact that when you read appellant's brief, you are going to see the presentation of what I would consider an alternate reality. There are no citations to the record. mainly because of the fact that many of the things that are said are not in the record. We tried in our brief to give you some of the examples of misstatements that were made, but in this particular case, you have a very unusual litigant who has been found by this court previously, by Judge Cooper on a number of occasions, by the special referee, to not be a credible witness and to be a very, very intelligent and remarkable woman nevertheless. I would be happy to...
Dobrish, could I ask you one question? I wondered if you could address that portion. I know a lot of things were appealed here, but that portion that deals with the order, I think it was in the judgment of divorce, directing the wife to pay a certain amount of child support, and whether, I know that portion of the trial was before a special referee, but it was in the judgment of divorce, and whether that was calculated appropriately pursuant to the governing statutes, and if you have anything specifically to state as to that.
A marvelous question. This was a very unusual situation, and Judge Cooper had been on the record essentially saying, how can there be financial issues in this case, in that my client had full custody? There was very little time that the mother had with the child.
And initially, it was supervised.
Initially, right, supervised. She makes no money. She has made no efforts to make money. She lives a very, very nice life. And I said she's a very unusual litigant. Judge Cooper got to know her, and so did I.
Well, I saw
these
with
trials.
You have 30 seconds left. You may want to get to the answer to her question.
Okay, the answer is that my client presented his tax returns. His tax returns and her imputed income did not amount to the compulsory cap. Therefore, all of her income and his would have been subject to the 17%. She was imputed to make $36,000 a year, a very, very small amount for a person with an MBA who is intelligent as she is and who had been in the financial services industry before she got married. And so there was the imputation of that amount of income to her, and the 17% applied. When it went to Judge Cooper...
Counsel, you're out of time, so if you
Was
can
just
wrap
trying
up
to answer the
your
question.
ultimate point.
I do not believe that there was any error that was made in connection with the determination of child support in this case. Judge Cooper put everything into the order that needed to be put in, and the calculation was correct based on the findings that had been made.
Anything further? Thank you.
Thank you, Mr. Dobrish.
Thank you.
Have a good day. People versus David Hernandez.
Good afternoon. Benjamin Rutkin-Becker on behalf of David Hernandez. This court must reverse Mr. Hernandez's convictions as the record demonstrates counsel's ineffectiveness. To begin with deficient performance, counsel failed to utilize readily available material that would have seriously undermined officers' accounts regarding the purported recovery of the complainant's cell phone. 3 officers testified at both the suppression hearing and at trial, and their hearing testimony simply failed to establish that Mr. Hernandez possessed the complainant's cell phone.
Can I ask you, you're talking about ineffectiveness of counsel, correct?
Yes, Your Honor.
Is there a reason that there is no 440 motion in front of us, so we could have, looked at it a little bit differently than on a regular direct appeal?
The reason, Your Honor, is because we know exactly what counsel wanted to do here, and counsel failed to do that. And we cite myriad cases on pages 43 and 44 of our brief in these exact circumstances where the appellate departments have held that no further...
What was it that counsel wanted to do?
So counsel wanted to undermine officers' accounts about the cell phone. This was, in the prosecutor's words in summation, a quote, devastating fact to Mr. Hernandez's defense. And counsel wanted to demonstrate that the officers had not testified to this previously. Now, the problem for the prosecution, I believe, is that the officer who actually conducted the search had no recollection of recovering the complainant's cell phone from Mr. Hernandez, and that remained consistent. But an officer who witnessed the search, Officer Alvarez, who testified at trial that he personally witnessed the search and remembered witnessing the search and the recovery of the cell phone. And then the officer who was with the complainant upstairs, the arresting officer, Officer Terrizzo, testified at trial that she was handed the phone by the searching officer. So in that way, at trial, the officer's testimony provided a neat version of events to establish that Mr. Hernandez possessed the complainant's cell phone, and that was the prosecution's argument in summation.
So I'm looking at Teresa's direct testimony, and did there come a time when you learned of property recovered from the defendant? And Teresa said, yes, I was upstairs. The phone was given to me. Well, the question was, and do you know what officer recovered that item, meaning the phone? Teresa says, yes, it was Officer Mitartin, and it's, how do you know that it was Officer Mitartin who recovered it? And Teresa says, he is the one who told me. He is the one who told me. So I'm not sure.
So at the hearing, Your Honor, she was not sure which officer. She testifies that she could not recollect which officer handed her the phone.
And are you saying that during the trial, this was not sufficiently?
Please
explain.
During the trial, counsel did nothing to successfully undermine the officer's accounts.
So when you say nothing to successfully undermine, does that mean he didn't question him at all on this issue?
No. So here's.
So he does question him on it, right? So he counsel attempts to elicit the differences in the testimony, correct?
Counsel attempts to do so, Your Honor, and that's why we know that this is properly before us on the record, because we know what counsel.
Okay, I'm not contesting that, so stay
Sure, Your
with
Honor.
me. So he attempts to impeach the witness with this information, right?
Correct.
And then what happens?
So this is the critical point, Your Honor. Alvarez, this officer who supposedly witnessed the search, he explains that, oh, I never said I didn't see the cell phone. I was never asked about that. Well, that is factually inaccurate. On page 25 of the hearing minutes, he is specifically asked about the cell phone, and he says he doesn't remember. And that is the critical.
But there's a photo of the phone, isn't there?
Teresa
Which
states,
Terrizzo
testified
signed
that they took a photo of the
as
phone.
having come from the defendant. Isn't that so?
So there is a photo of the phone. It's actually unclear to me. We had, without going too far afield, we had difficulty obtaining the exhibits at the time we briefed the case. Upon review, I'm actually not sure that that notation is in the trial exhibit, but in any event, more importantly, that notation was not relied upon at trial.
But the victim acknowledges to the police officer, that's my phone, and on top of that, she enters her passcode to open the phone. So clearly, it's her phone. I don't understand.
So we're not contesting that it's her phone, Your Honor. The problem is that the hearing.
And counsel, I get it, okay? The attorney at trial could have perhaps asked more questions to beat this officer over the head about what he said at the hearing. At the end of the day, what the jury heard was that a phone was recovered from the defendant and that the victim was able to open the phone. It doesn't take a rocket scientist to figure out what that means.
I see my light is on, but may I respond to that, Your Honor?
And in summation, defense counsel argued about the discrepancy, about the deficiency in the police testimony about the phone. So it's not like counsel didn't make use of it.
I will allow you 30 seconds to address us both.
I appreciate that. So
Go ahead.
the problem is that counsel tried to make these arguments, yes, but she failed to establish the proper record. The jury thought that this witness perhaps hadn't testified about the phone before, but was just simply never asked about it. And that is a huge difference as to a critical fact between being specifically asked about the phone, has no recollection of it, and now at trial his memory is magically improved.
Better than it was on the, closer to the event.
And the jury had no idea about that.
All right.
Thank you.
Thank you.
Good afternoon, Your Honors. Noreen Stackhouse for the people. The problem with counsel's argument is that Alvarez did testify at the hearing that he knew the victim's phone had been recovered from either defendant himself or his backpack. I'll point you to page 23 of the hearing testimony. He testified, I remember asking him about the credit cards. They had a female's name on it, and I think someone took it and made sure it wasn't the female upstairs and the phone or something like that too. But it was the female's phone as well. So in that regard, even if counsel had done a better job cross-examining the officer, she couldn't change the fact that he did remember that the victim's phone had been recovered at the scene from either defendant himself or his backpack. And again, as Your Honors pointed out, we know from the paper record where the phone came from. Teresa wrote down that Mitteriton, don't know how to pronounce that, recovered the phone from defendant's pants pocket.
And again, Teresa took a picture of the cell phone.
Correct. The exhibit is the photo of the cell phone with a handwritten notation that says...
Right. For Teresa, I think, put the name and the shield on the bottom of the...
Correct, Your Honor. And as Justice Friedman pointed out, counsel highlighted all of the inconsistencies, of which there were many, of the officer's testimony in her summation. She really tried to hammer that home. And beyond that, the crime was independently established, aside from the cell phone, by the victim's testimony and the testimony by the hotel employees. If there are no questions, ask you to affirm. Thank you.
Thank you. You have 2 minutes.
Okay, so to begin quickly with this notation that was on the photograph, again, that was not relied upon at trial. Again, at trial, that is hearsay, and that is precisely the problem, that we don't know where the phone came from. At the hearing, we did not know where the phone came from.
I'm sorry, what's hearsay?
A notation by Teresa that a certain officer recovered a cell phone from Mr. Hernandez without independently establishing that that was actually the case, and the officer's hearing testimony, again, failed to establish that. Alvarez did, in most favorably to the prosecution, Alvarez says at the hearing,
Are you suggesting that the failure to hammer this home as you would have liked, right? And I'm not saying you personally, right? Somehow was so egregious, so failing in legal acumen that it overrides the victim's identification of the defendant, the fact that the phone that was recovered, she was able to open, thereby establishing her identification of that phone. I mean, there is like a slew of pieces of evidence here. So I mean, I'm trying to understand how you think the failure to cross-examine on this one issue, because that's the only thing you're really focusing on, would have resulted in a different verdict.
well, in the prosecution's words, again, this was devastating to Mr. Hernandez, and this was tied into the jury's evaluations of the credibility of Mr. Hernandez and the complainant. This was a supposed smoking gun found on Mr. Hernandez, and the jury should have known that the officer's testimony previously had not established that.
Counsel, with regards to, there's one other wrinkle here, right? Isn't it possible that defense counsel did not go full throttle as you suggest that defense counsel should have, because defense counsel was worried about opening the door to items that were precluded, i.e. the credit cards?
No, Your Honor, and the portion, the limited portion that counsel did try to use actually presented this issue with the credit cards. The portion of the hearing testimony in which Officer Alvarez says he didn't remember the phone presented none of those issues. And to be clear, the problem here is that Alvarez himself provided an explanation for why he had not mentioned this previously, that was false. And this was clearly important. The prosecution knew it was important. On page 440 of the trial record, on redirect, the prosecution elicits again from Officer Alvarez, and you were never asked about the phone previously, correct? Again, he says he was never asked previously about it. Again, counsel fails to correct the record. There were different parties, the prosecutor, counsel, and the judge that had not been present at the hearing, and it's counsel's duty to minimally investigate and to
But
be...
you know what, counsel? Your client, the defendant testified in this case, right? He testified at trial. The defendant testified that he took property from the victim. He claims that this was all some type of sexual encounter that went astray, that they had been drinking, doing drugs, etc., and that at some point in time the victim went off on him and attempted to assault him, and then he admits, though, to taking property, in the backpack and including, well, I mean, and property. So it seems to me that based upon his testimony, he admits to taking a cell phone. So still, I'm not understanding why the cell phone is an issue.
That's not entirely correct, Your Honor. He admits to taking weapons that,
He
per his
grabbed
testimony,
he grabbed her and took some of her things, is what he testified to.
that he took the mace and pipe that, in his testimony, were used against him. And I think it's helpful on this score to note exactly what the prosecutor says about his testimony and to note how important this cell phone was, because in summation, this is pages 784 to 85 of the trial record, the prosecutor points out and asks the jury to consider that, quote, not a single question was asked of Mr. Hernandez regarding the phone, and that he was, quote, trapped by this evidence. So even in evaluating the credibility of Mr. Hernandez and the complainant, the prosecutor saw this as tremendously important evidence, and there is a significant probability that had the jury been aware and had legitimate reason to question the officer's account about the officer's recovery of the cell phone, this case would have been a lot different.
Thank you.
Thank you.
Carson versus JAD Realty. And you have 3 minutes. Hi.
Judy Shalmetzi from Wilson Elser for JAD Realty. I would normally submit in the absence of my adversaries, but I wanted to talk about port parties. Because I do think ultimately the case is going to come down to that. I think it's clear under paragraph 30 of the lease that the tenant was obligated to make all repairs and replacements to the sidewalk, and that language has been interpreted in the Calido case and held on a lease exactly with this language to mean that when you have, that means if you have to replace the sidewalk flag, you have to replace the sidewalk flag.
So you're saying that this tenant had an obligation under the lease to make structural repairs to the sidewalk?
Yes, Your Honor. If the problem is with the sidewalk flag as it was here.
Wasn't it Daniels, was it, from JAD, that testified that it wasn't
He
the
sure
tenant's-
did. Apparently, if the tenant had come to him and said, fix it, he would have. But that's not to say that he had an obligation to do it. So it's true, but the reality is that the lease itself.
Well, doesn't he have an obligation to fix anything that is obvious? And there's no question that this slope is obvious. It is 3 times greater than what is permitted under the statutory construct of the administrative code.
There is no doubt in my mind that this landowner is going to be liable to the plaintiff for the slope of the sidewalk, no question. But the issue is between the owner and the tenant, and that is a function of the lease.
But why does a tenant have to advise a landlord of a open and obvious defective condition in front of their premises?
But it's not about that. It's about the fact.
Oh, it is about that. You are required, you have a duty as a landlord to correct any structural defects to the sidewalks in front of your premises.
And that duty, the beneficiary of that duty is the person walking on the sidewalk, who I expect is going to recover from the landlord because the landlord should have fixed the sidewalk.
Okay.
No question about that.
You're saying as between the
As between the owner and the tenant, though.
Okay.
as between, and that's the only thing really.
So what portion of the lease do you say controls that situation?
So there's two portions of the lease that I think are relevant here. Paragraph 30 obligates the tenant to make all repairs and replacements to the sidewalk. That is the language. That language has been before this court. It's a form lease, so this same exact form lease.
That's not the rider, that's the main portion
The
of the
main,
lease.
it's paragraph 40 of the main portion is the part that's hard to read. And in Colado, that has been done. That language, when it says you have to make all repairs and replacements, that includes the sidewalk flag, which is what this is. So that part theoretically is easy. And then you have the indemnification language, which is paragraph 48. Now this is the one where it's written like we write now and the full length of the width of the page. And that indemnification provision is absent in Colado,
What about
but it,
paragraph 4 of the lease, which provides that owners shall maintain and repair the public portions of the building, both exterior and interior, while tenants shall throughout the term of this lease take good care of the demised premises and the sidewalks adjacent thereto, and I'm skipping words, and at its sole cost and expense make all non-structural repairs thereto as and when needed to preserve them in good working order and condition. Replacing the sidewalk like this clearly would be a structural repair, would it not?
so yes.
So
But-
doesn't that leave it on the landlord?
Doesn't, and again, Colado, same lease, same provision, same argument made in
So how do
Colado.
you interpret
And the reason
paragraph 4?
Because paragraph 4 says you're gonna do A. It doesn't say you're not gonna do B. Paragraph 4 says you're gonna do non-structural repairs. But then there is, in paragraph 30, a specific provision relating to the sidewalk. Now, we're not talking about other parts of the building, we're talking about what are we
paragraph
doing.
4 also says that owners shall make the repairs.
I'm sorry, Your Honor?
Doesn't paragraph 4 also say that the owner shall make the repairs?
Right, owners shall maintain and repair the public portions.
And paragraph 30 cannot, by its construction, make non-effectual paragraph 4.
Oh,
You can't, if paragraph 4 becomes meaningless through paragraph 30, then it seems to me paragraph 30 has to go.
Well, paragraph 30 is specific to the sidewalk, so that is the specific
So is
provision.
paragraph 4.
Paragraph 4 has to do with
And it talks
more.
about the sidewalks and structural defects in the sidewalk. You can't give in one provision and take away in the other and say,
Your Honor-
those two are.
I guess my point is either Port Parties or Colado is gonna have to go then, because this was exactly the
Counsel, and
argument in
I
Colado.
know it's not controlling, that the lease controls. I want to stress that as I make this comment. It does seem a little bit of a stretch, does it not, as you look at the picture of that sidewalk, to say that this is the tenant's responsibility to replace. It's not in sort of everyday business. You would not think that it's the tenant's business to replace that sidewalk. Look, if the lease unequivocally says it is, obviously, but
Your Honor, if I were the tenant's attorney looking at that lease, I probably would have a conversation with my client about, do you really understand the scope of what you're taking on
No,
here?
Counsel, I don't want to belabor this, but paragraph 30 talks about heat and cleaning.
It does, that too.
I mean, that's the heading of paragraph 30 is heat and cleaning. And it talks about, shall maintain the demised premises, keep demised premises clean and in order to the satisfaction of the owner.
Correct. So 2 points I would like to make about construction of contracts in those circumstances. One is that the headings don't control the language that is actually in the contract. And again, as I hate to belabor the point, but it very specific, all is short, but it's not ambiguous. It says all replacements to the sidewalk that are necessary, which is what this was. So there really can be, in my mind at least, no question that this falls, and again, under Colado, very clearly, same lease, same paragraph.
Did Colado have such an obvious structural defect in its factual background?
It was a side, it was the flag.
Was it because this is like a gargantuan defect.
Well, it requires, what?
Ray Charles could see this one, okay?
I will not.
You understand?
It's funny, but I'm just gonna walk away.
I borrowed that from my old PJ Luis Gonzalez. It is so obvious. Everyone can see that.
What I know, Your Honor, is that the Collado defect required replacement of the sidewalk flag. That is what that tenant was required to do under this form, same form.
You're not telling me whether it was as drastic a defect, but I'm gonna check. Thank you.
Thank you, Your Honor.
All right. All right. People versus Hurt.
Never mind, never mind.
May it please the court, Shayna Watrous on behalf of Ms. Hurt. The lower court should not have consolidated the two indictments, given the weak evidence in support of both. The jury was unlikely to have convicted my client of the second incident if the evidence of the first hadn't improperly bolstered the evidence of the second. When
He got acquitted of the first.
he did get acquitted of the,
So
or,
you're saying
I'm sorry.
that they used the evidence that they didn't believe, didn't credit, acquitted him, but then used that evidence to convict them on two.
When you look at the evidence that supported the idea that Ms. Hurt committed the second crime,
This jury was either going to believe that he committed one, two, or none.
the jury may have believed that Ms. Hurt's phone was used to call in the first, which would have bolstered the evidence about the second. When you look at the evidence of the second, we see that the
But that wasn't the only evidence.
No, there was...
That wasn't the only evidence, right?
Sure, correct. And the evidence in the second incident was that the complainant gave the wrong height and the wrong outfit. The eyewitness to the robbery gave again, a height that was different from Ms. Hurt's, or an outfit that was entirely different from Ms. Hurt's. The complainant couldn't identify Ms. Hurt in a photo array. When Hurt was identified, it was in a very suggestive lineup, and the complainant said that...
What was suggestive about it?
The lineup made it seem as though, so the complainant had said that...
I thought everybody was seated, had a covering in front of them so that their size could not be discerned, and they had head coverings, right? Because there was a description of a very peculiar hairstyle, and so they covered the hair as well. So what was suggestive about that?
Ms. Hurt appeared to be the youngest and skinniest of the group, and also notably, the complainant and the eyewitness said that the person that did the robbery was very short. Ms. Hurt is 6 feet tall, and they made everyone sit down, which made it look as though Ms. Hurt was the shortest of the group, even though she was one of the tallest. So that is notably suggestive.
I'm trying to understand how that was suggestive, though.
And counsel, I also wanted to go back to your initial statement that the motion to consolidate the two indictments should not have been granted because of the lack of evidence as to one or something as opposed to the other. The motion to consolidate is made prior to the trial. It's made prior to the judge's understanding, I guess, of what the evidence is. I mean, that's not the basis for a motion to consolidate, and whether you grant a motion to consolidate or not.
Your Honor, prior courts have also found that when there's weak evidence of both, as there is in this case, it's improper to consolidate based on 222C, which is this, it's improper when evidence is weak and the jury is likely to do as the prosecutor told them to do, which is to find this propensity.
Well, I mean, again, what was presented is you have two instances where they're both robberies of delivery individuals, right? Where the same type of MO is used, where there's a telephone call ordering food, and then the victims go to the location and they are robbed. And so I'm not understanding again how when a judge is presented with that, or when the judge was presented with that, that they would not think about judicial economy, same or similar statutory provisions, whether or not there's proof of the MO, as I stated. I'm not sure how you could state that it was improper to consolidate the indictments.
Your Honor, everything that you're talking about in terms of there being similarities, common MO, that's all this Molyneux argument that would be proper if the court had consolidated based on 2B and not 2C. The court did not consolidate on that basis. So you have to look with.
You said the case was weak. Didn't they have a statement from the defendant putting himself into the case?
Ms. Hurt only said that they were in the hallway at the time, but not that they committed this. There was just a video of that, and there is no video of them.
There's a video, there's his phone, the phone calls.
The phone
Wasn't there a witness also to that second incident for which the defendant was convicted? The neighbor came out.
Ms. Dorsey?
The neighbor exclusively says that it was a 5'8" person who was wearing a dark hoodie that was not the 6-foot-tall white coat that.
Well, you know, that measuring somebody is a little difficult when they're in the process of beating up somebody on the floor.
And 5'8" is not that far from 6 feet, depending upon how short or tall you are. But it goes back to the whole issue in terms of lack of prejudice. I don't understand how you can argue, let me rephrase that. Bottom line is, he was acquitted of your client, was acquitted of one of the robberies. So obviously, the jury did not, say, well, therefore, if the defendant is guilty of one, then they must be guilty of both.
I would just reiterate that if you look at the evidence of the second incident, it seems highly unlikely that there would have been a conviction if there hadn't been this.
Let's look at that evidence. Doesn't he, in the second one, say that his phone number is 917-913-4763? And isn't that the number that was used in the calls for the first incident?
And that's exactly the point, that it's prejudicial that the evidence of the first incident was brought in the second. It doesn't seem likely there would.
What the evidence is, the statute authorizes this this consolidation because of the nature of the crimes that have been committed, and you say that this is a weak case. I don't know how you can make the statement that this is a weak case in the face of that phone number evidence.
It is weak if you were to sever both of them, but otherwise, the jury would be improperly considering the evidence of the first. I do want to turn to the excessive sentence.
You can do that on your rebuttal time.
Excellent, thank you.
You may proceed.
Good afternoon, and may it please the court. Jennifer Westfall for the people. Trial court properly granted the people's motion to consolidate. Robbery counts were properly joined under 222C, 222C, because they were the same or similar in law, thus saving judicial time and resources. Defendant also failed to show good cause why joinder would be improper, essentially just arguing that the crimes were too similar and the jury couldn't possibly listen to the court's orders.
Could the jury have reached the same verdict on the second incident without the cell phone evidence?
Without the cell phone, yes, I believe so. First of all, Bersuto identified defendant in the lineup, but even without the lineup.
But there was a miss on a photo array, correct?
Yes, of course, but I think it's different if you're looking at a picture of somebody versus seeing somebody in person. But even without the lineup identification, there's ample proof that the defendant participated in the robbery.
And to be clear, the jury heard the fact that the victim here was not able to identify the defendant in the photo array, correct?
Yes, extensively.
Yes.
First, defendant was captured on camera and identified himself on camera to officers with Hill walking together closely, entering the building where neither of them lived shortly before the robbery, taking the elevator exactly to the 16th floor where the food was ordered to. And then just after Bersuto got off the elevator, within seconds, defendant followed across behind him. Dorsey comes out.
Was there also evidence that when the food delivery gentleman arrived at the building, that he called to have the person who ordered the food come down?
Yes.
And they did not come down, forcing him to go up to the 16th floor.
Yes, and he
Did that number match the number given by the defendant at trial?
No, so the First, defendant gave a phone number that matched to the first robbery.
Okay.
There was a second phone number used for the second crime. The people's argument was that the 80% of the phone calls, or upwards of 80% of the phone calls, matched between the two phone records, and that it was more highly probable that either they knew exactly the same people and were closely associated, or that defendant owned both phones.
Was it also true that there was never a call between the two phones?
I'm sorry?
There was never a call between those two
Yes.
phones?
Yes, they never called each other, again suggesting that defendant owned both phones.
So it was the second phone that received the call to come downstairs?
Yes. Yes, and you see the back and forth of the phone calls, and Bersuda did testify that this was unusual. Most of the time, people come downstairs to get their food. But what happened was this forced Bersuda upstairs to the empty hallway where defendant and Hill were waiting for him.
And that was the one floor, did that floor have a camera?
No, of course. Dorsey confirmed that nobody else was on the floor. Bersuda testified nobody else was on the floor. And as soon as Dorsey came out, they both fled and were again captured on camera, leaving the building together shortly after the robbery. The telephone records were an aside and icing on the cake kind of thing, but the video footage puts defendant there and leads inexorably to the conclusion that defendant and Hill were the robbers.
And the excessive sentence claim, the defendant was a violent pred, received 10 years?
My only comment is that this was a serious crime. Sorry, one second. Defendant received a mid-range sentence that was fully justified by the serious nature of his crime, of their crime that they committed. It was a clearly premeditated plan where defendant and Hill called in a food delivery in order to lure a victim who was likely to have cash and a cell phone to a location where they could expect to rob him without interference. In doing so, defendant targeted a vulnerable section of the community. Since low-level food delivery services are most commonly provided by immigrants like the victim, who may have had great difficulty in communicating in English or even Spanish in this case, and may be reluctant to involve the authorities. Moreover, the manner in which the robbery was committed involved gratuitous violence. Defendant and Hill did not demand anything from the victim. They just simply began beating him and continued to do so even until they had taken the property, until the neighbor came out. So under those circumstances, I think the sentence was appropriate.
Thank you.
Thank you.
All right, counsel, you have time now in rebuttal.
Thank you. Ms. Hurt's 10-year sentence was excessive, and they should have received closer to the minimum of 7 years. I would note that their co-defendant for the same incident received no prison time.
Was the co-defendant a second felony offender?
I'm not aware of that, no. But in any case, Ms. Hurt could have received a lower sentence, and the co-defendant, even if not a second.
This was the defendant's third robbery conviction?
Yes, Your Honor, and I do want to talk about, Ms. Hurt was 22 years old, was coming off of a childhood of experiencing bipolar disorder and schizophrenia, and also dealing with this suppressed gender dysphoria. They had experienced a childhood of abandonment by the people who were supposed to be there for them, was homeless, was dealing with, experimenting with drugs in order to, calm the voices in their head. And so, when you look at their record, I think you have to think about it as in terms of like, this is what you might expect from someone experiencing that kind of a childhood. I would also note that reduction is particularly urgent where they have been the victim of sexual violence in prison. They're present as a woman and are held in men's prisons where they are particularly vulnerable. So she can't be safe while she's in a men's prison.
The maximum would be 15?
I believe it was, I know that the prosecution was asking for 13. I'm not sure about the maximum.
The people asked for 13.
Yes.
And your client was received 10, right?
Yes, that's right.
So I thought the max was 15, and I thought the minimum would be maybe 7, or I think so.
It's correct that the minimum's 7, and we're asking that this court.
The range was 7 to 15.
7 to 15. So you're asking for 7?
Yes, Your Honor.
So it's 3. It was 3 above the minimum, right?
Correct. Yes. Correct. It's particularly urgent, just for her safety and appropriate given the very lenient no prison time sentence that her co-defendant received for the same actions. Thank you.
Thank you. Okay. And last but not least, Mazzone versus Alonso and Elcar and Thatcher. You may proceed.
Thank you, Your Honor. May it please the Court, Erin McAvoy for defendants, appellants, respondents, Alonzo Endelkar and Fasher, and Katanya Fasher. The law in this department on legal malpractice is well settled, and defendants here are entitled to summary judgment because plaintiff cannot demonstrate as a matter of law proximate cause and damages. In order to satisfy proximate cause, plaintiff must show that but for the negligent advice she received from my clients, that she would have prevailed in the underlying matter. And in the underlying matter here, we have a written arbitration award, and that arbitration award identifies 4 bases for liability: laying claim, affirmative solicitation, disparagement, and common law solicitation. However, the lower court assessed that award and placed all the liability on the advice that my clients gave on solicitation. And the lower court further rewrote the standard for proximate cause and stated that if the liability in the award due to the solicitation advice was anything more than 0, then my clients were liable for malpractice, liable for the entirety of the award, and liable based on the negligent advice for all of plaintiff's attorney's fees. And that simply does not comport with the law of the state on malpractice. The award identifies laying claim as the first basis, and plaintiff laid claim to the clients prior to receiving the advice on solicitation. Plaintiff testified numerous times during the arbitration that she was in fear of losing her job at RBC. She knew that if she did not claim all of the group's clients, that she did not have enough assets to keep her producing commissioned FA position. She was told that by her manager when she had numerous conversations with him days after she was assaulted by Ms. Schusterman. So Ms. Mazzone went ahead and she laid claim to those clients, not just to Mr. Moran, but also to the HR director who testified at the arbitration hearing. She went beyond the scope of the interview about her assault, and she stated to the HR director, "I need to retain my job. I'm a single mother. I support an elderly parent. And if I don't keep these clients, that I am going to lose my job and not be able to maintain the lifestyle that I have for my daughter and my mother." So plaintiff went ahead and laid the foundation to keep the clients before my clients ever gave advice on solicitation. However, even more glaringly, the award specifically delineates disparagement, which my clients advised against, and Ms.
Those discussions with Mr. Moran, those initial discussions with Mr. Moran, go on before she consults the defendants. Is that correct?
It's not before she consults the defendants. It's
before they give her advice.
Correct. Before they give her the advice on solicitation. She was assaulted on July 25th, and she testified at the arbitration that between the day after the assault and when she met Mr. Moran at the Algonquin Hotel, she had numerous conversations with him. And when she did meet him in person was when he told her that you will not be able to keep your job with the level of assets that you have right now. I could put you in a management position. But she had testified that she didn't want
Which meant that she had to lay claim to some of these clients in order to stay at RBS.
Correct. If she was not able to retain the assets, then she would not be able to keep the position that she had. And moreover, it was undisputed.
She had $5 million under management?
She had $5 million of her
That was insufficient for RBC to keep her in that position?
Correct. RBC had presented her with a $740,000 promissory note, and that was based off the assets.
If she lost the job, she would have to repay the loan?
Correct.
And that would be true if she was in the management position, too, she would have to repay the loan?
Correct. And she testified that herself numerous times at the arbitration. She had stated that she had previously paid back a loan with Ms. Schusterman at a prior employer. And we provided expert evidence that said that it's standard in the industry, if you are not a commission-based FA, that you're going to have to repay the loan. And that here is simply why she doesn't have any damages. She was able to maintain her job as a commissioned FA. She did not have to repay the $740,000 promissory note. She made over $300,000 in commissions on the clients that needed to be serviced at RBC before Ms. Schusterman had another job and before Ms. Schusterman could transfer them to a new employer. And she managed to keep $43 million in assets that weren't previously hers.
What
And
about the $1 million that she was able to keep under the arbitration award? Wasn't that pursuant to the terms of the agreement that was entered into by Ms. Schusterman and Ms. Mazzone?
Yes, she was allowed to keep the $1 million, and there was a liability placed on her of $548,000 based on the 4 separate prongs of liability, and disparagement weighed heavily on that. She didn't just disparage to keep customers and clients like the lower court attributed to. She did it to friends and to colleagues, to coworkers.
And those acts of disparagement were not part of the advice.
No, we advised specifically against disparagement,
it.
and she knew. She was 20 years in this industry. She knew how to transact business, but this underlying case was tantamount to a divorce. They had a personal romantic relationship that soured, and she initially came to my clients for an agreement to protect her interests in the business because she was fearful. Before this even happened, she knew that her professional relationship with Ms. Schusterman could go south. But today,
all of this leads to your position, does it not, that even if your client gave incorrect advice, the end result is that she ended up in a lot better position than she would have been had she followed their advice.
correct. She has not shown the proximate cause, and there's no damages here. She's in a much better position today than she was beforehand. And if she, as the lower court suggested, took the $1 million and walked away from all the group's assets, she would need to rebuild her business, and she would need to repay the $740,000 promissory note, reducing the $1 million way more than it was by the arbitration panel.
Thank you. You have time on rebuttal.
Thank you.
And you have 6 minutes.
May it please the court, my name is Mark Alonso, a defendant, appellant, and respondent pro se. I'm going to address the advice itself because, unfortunately, there are times, as was noted in the Parksville case, where sometimes you get a client who's in a serious dilemma where every possible course of action has risks. Ms. Mazzone didn't come to us, as Mr. Freeman will suggest, and convince the court, saying, what should I do? No, she came to us after the agreement, after she got hit by Ms. Schusterman, and said, I have to keep these customers. And she had a good reason to. The judge in the lower court said, well, what's the problem? All you have to do with these people who are worth millions of dollars, just say, the parties separated amicably and have gone their separate ways. Click. That will get you fired. It would get you fired in any business, but in the securities business, clearly, your business is knowing your customer, dealing with them. People need checks for nursing homes, tuition, everything. So the judge said, yeah, but it would be fine if you did that. There's no risks here. She should have done that because they won't fire her. They won't collect the note. They won't cut off the customers. And all of that was belied, not just by our experts. It was not refuted by Ms. Mazzone's expert.
Was your advice, well, technically, you could solicit, you have a right to solicit under the circumstances, but you shouldn't do it and you should get someone else to do it. Get the bank to do it, get a different manager to do it.
And that's, yes.
Advice, a little bit you're trying
No,
to
no, that's right. But keep in mind, I want to emphasize the timeline because that's why I said she didn't come to us and say, what should you do? She came to us the next morning, said, I got to keep this. I get a stream of income as a commissioned salesperson, and the only way you can do that in the securities industry is to keep them under your broker number. And she was the back office person. Mr. Moran, starting the day of the assault, July 25th, not August 25th when the solicitation advice was given, was you just don't have enough assets to go on a team. Mr. Neville, our expert, said that's the level you have if you just say, Mom, if I become a stockbroker, could you give me your retirement account? That kind of assets gets you a trainee job. They had just spent millions to recruit this team. Ms. Mazzone had to earn back $741,000, and it's physically impossible. Now, the development that came to her And why she wouldn't do that is because she would have gotten fired, wouldn't have been able to support her mother or daughter. Those customers, as Mr. Moran said, and as Mr. Neville said, normally in the industry, they get assigned to other brokers. You can't look at their accounts. Only that person who's on can look at the accounts, call the customer. You can't poach other
Indeed,
brokers.
RBC asked her to identify which clients she wished to keep under her
Yes.
umbrella, and the rest would be reassigned to others.
Right, but keep in mind, that was a month after she had been laying claim. She laid claim to the customers to Mr. Moran. She went to Ms. Luz, the HR director, said, I got to keep these. And Ms. Luz so testified. And as you say, then it was a fait accompli. She'd already breached the agreement. And the minute the escrow money was dispersed to her, Ms. Schusterman sued for false imprisonment, for solicitation, but for basically defaming her by taking a lover's quarrel, going to RBC and getting her fired. And part of our job at that time was we laid out for her all the options, one of which was reconcile. It was 2017. People didn't know about remote work, but it's in the record that that was one of the offers. When you consider this, though, her risk that she took, it's not just a risk. You call it a risk-reward ratio. Two things become apparent. She didn't pay back her note. That's $740,000. If she had taken the $1 million and fought, panels routinely, when you have these kinds of interpersonal disputes, cut it 50-50, which is exactly what they did here. Number three, she not only kept $43 million worth of assets that in her life, 20 years in the business, she'd only gotten $5 million, and I actually did the math. To get to $43 million from the day she got slapped, she'd have to work 129 years. And then, on top of that, she also collected the money. So imagine 300 golden geese laying golden eggs, but their owner leaves and isn't going to get another farm for 6 months. Well, for 6 months, Ms. Mazzone was collecting those golden eggs that she should have been giving to Ms. Schusterman. So even if they left, and some of those customers were Schusterman's own family, and Ms. Mazzone collected all that income. And the court just said, nah, she would have gotten the money anyway, she would have kept her job, and anything you told her was based upon, or anything she did bad was based upon the fact that we told her to solicit. No, we told have other people solicit. And the panel pointed out, laying claim, not us. Affirmative solicitation, exactly the opposite of what we said. Disparagement, and she actually went and topped that. She went and hacked into her partner's Verizon and Gmail accounts. She called other people in the industry and their former teammates, the employees who supported the team after Ms. Schusterman went to Janney and asked them to quit working for her because she was untrustworthy.
Okay.
All of those things together, and I want to throw one more thing in because I see the light.
Yes.
The reality is,
You got a lot in.
I mean, that was
Can I tell you something?
Wow.
It has been, I talk quickly, and the problem is there is so much in this award that was missed, realities of the industry. But in the middle of it, it is routine that if you get found guilty of malpractice, the collateral causes of action go away. Breach of contract, unjust enrichment. Yet, in this case, without any discussion in the 4 hours, and there's no written decision, somehow there's breach of contract. And Mr. Freeman's going to come up here and say that, well, even if you reverse the malpractice award, we still won breach of contract. And in fact, tomorrow, we're supposed to start a reference or an initial conference on the legal fees attending that. Because the $731,000 we've already paid to Ms. Mazzone was not the total amount they seek. They also want the damages for legal fees unnecessarily incurred by advice we didn't give. So with all of that, the breach of contract action should be addressed, and that's why we're seeking a reversal of the entire judgment.
Thank you.
And I could go on all year.
I bet you could.
And you kind of did.
Okay, so I must have missed a party because I have 6, 6, 6, and 2. You're not in it. Who are you here for?
Donna Russo.
Okay,
She's an appellant as well.
Right.
all right. So I'm going to give you 4 minutes.
Okay, great.
Go ahead.
I don't speak that fast. I hope that's okay. Good afternoon, Your Honors. May it
Work
please
it.
the court. Alexandra Camella, Wood, Smith, Henning, and Berman for the appellant Donna Russo. Ms. Russo is seeking reversal of the lower court's decision with regard to her summary judgment motion.
She worked in her own law firm?
She had her own law firm, and she is an attorney for the city of Bayonne.
So, for what?
The city of Bayonne, New Jersey.
Okay, and the court found that there was an issue of fact as to whether or not there was a attorney-client relationship between the plaintiff and your client?
My understanding is that the issues of fact the court found were regard to Ms. Russo's conduct or advice, discussions with.
Was there an attorney-client relationship between the plaintiff and your client?
Our argument is no. They were friends for 40 years. They used each other as sounding boards. They discussed many different topics together.
Ms. Russo said that she basically proofread the document here.
Yes, Your Honor.
Is there any evidence that would refute that? Emails, anything?
My understanding is that the emails that exist exchange a draft of the Fur Gang letter where she reviewed it for grammar and syntax. That's my understanding of the evidence.
So that's what I'm saying. In her responses to that email, was there anything beyond that?
No, Your Honor.
Okay. All right.
So our argument is that Ms. Russo, on her summary judgment motion, offered the opinion of Bennett Wasserman, who is her legal malpractice expert. He reviewed all of the documents in this case and essentially opined that there was no attorney-client privilege between plaintiff and Ms. Russo, and if there was, Ms. Russo adhered to the applicable standard of care. Plaintiff, respondent, and what I will call the AAF appellants, they didn't provide any rebuttal expert opinion, and I think under the applicable case law that's cited in our brief, that's required to create a genuine issue of material fact on a summary judgment motion that would require denial.
What I did not understand was that, from the record, I thought that Ms. Russo proofread the letter, but I thought that Russo also suggested or advised that the letter should not be sent.
She did, Your Honor. She reviewed the letter. She provided, the changes that she provided were grammatical, and advised the plaintiff that she didn't think the letter should be sent, but to check with her counsels who were representing her for this partnership agreement in the FINRA arbitration and had more knowledge of the underlying facts of the matter.
And so therefore, the argument is that liability attached to Russo because she advised that the letter not be sent, or because there was some type of attorney-client relationship by her proofreading and suggesting that she contact her other attorney?
Our argument that there is no liability for Ms. Russo. We believe the lower court's decision should be reversed. Summary judgment should be granted.
Did the plaintiff actually oppose your motion? It did not appear.
No, Your Honor. Plaintiff didn't oppose our initial summary judgment motion. She did not oppose our appellate brief. The Alonzo Andelkar and Ms. Focher also do not oppose this brief, and my understanding is that Mr. Alonzo opposed it just as to the existence of an attorney-client privilege. He does not offer any rebuttal as to the standard of care or our arguments regarding the expert opinion.
Okay. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Michael Freeman, Greenberg Freeman LLP, for the respondent.
Can we just go and stay with Russo for 1 second? So what is the issue as to Russo? And also, did you actually oppose the motion for summary judgment?
Simply stated with respect to Russo, there was no expert opinion proffered by the Alonzo firm. So I don't know how they can prove a case against Russo with no expert report. That's what we had said below. That's what we said now. Putting aside the whole issue of the attorney-client privilege between Russo and Mazzone, that's almost a red herring because they never came forward with an expert to prove their case.
You sued
We sued Russo as a protective case because the case law provides that if a jury were to find liability with respect to both Russo and the Alonzo firm, then we could only recover against the party we sued. My client never had any reason to believe that Russo had done anything wrong, but on my advice, just as a protective claim. So, I mean, that's all with respect.
What is the allegation as to Russo?
The allegation is as to Russo, from my client, there are none. The allegation as to Russo with respect to the Alonzo firm is that she assisted in giving the advice, which, you know, it could be an issue of fact, but without an expert, that part of the case cannot go forward. Now, if I may turn to the direct case that we have against the Alonzo firm. Mr. Alonzo said that we should emphasize the time. He wanted to emphasize the timeline. I also want to emphasize the timeline. So my client came to the Alonzo firm in April of 2017. She was in this business arrangement with Ms. Schusterman, and she wanted.
Why don't we don't need the whole history.
Right.
Let's go straight to
Right.
what happened at the firm, the
Okay.
slap and everything that
Okay.
came after the
So
slap.
but you see, the provisions of the contract are important, and I'm just going to raise 2 points with respect to the provisions of the contract. One is that upon termination for any reason, my client was going to get $1 million to start over, have a fresh start. The other point of the contract is that it was expressly.
Wasn't the underlying purpose of the contract was in the event that your client lost her job as opposed to Ms. Schusterman losing her job? I mean, wasn't that the way it was sort of phrased and focused?
Respectfully, Your Honor, how it was set up was it was anticipated that upon moving over to the new firm, Schusterman was going to tell my client, see you later. And my client never had an agreement to talk about that spoke to what her share of the business was. So in order to move over to this new firm, my client insisted that she be paid some amount of money. It was agreed that it was $1 million, and it was explicitly contemplated that my client would leave the firm, leave the group, or leave the firm.
That's not what happened.
After
That's
that. And that's
exactly not what
exactly
happened.
what happened. And that's exactly what should have happened. And my client sought advice from the Alonzo firm as to her rights and obligations under the contract. Now let's start with the slap, as Justice Manzanet said. The slap occurred on the 25th of July. The termination of Schusterman did not occur until August 22nd. So during that period, the contract had not been terminated. So Mazzone was working with the group. All her clients were part of the group's clients. She was not seeking advice with respect to the termination of the agreement because the agreement had not been terminated. So to the extent that she went to Mr. Moran and said, I would like to keep my job, I would like to keep working with those clients, none of that has anything to do with the advice that she was ultimately seeking from the Alonzo firm. Now, upon the termination of upon the firing of Ms. Schusterman, within an hour of Ms. Schusterman being fired, what does Mr. Alonzo say? Take the $1 million and let's declare, quote unquote, open season on the clients. Let's have people solicit all of the clients on Schusterman's list.
Where is there proof that that's what they said? I read a lot of things that suggest that that's not what they said.
Okay.
That solicitation and disparagement were clearly a no-no. I thought that that's what was their
At
advice.
the record.
Yes.
Page 3852 of the record. Pardon me if let me just give me a moment to pull it out, please. .3852 of the record. Within hours of Schusterman being fired, this wasn't expressly covered. This being Schusterman being fired because it was anticipated that it was Mazzone who was going to be fired by Schusterman. So Rosa should invoke termination on 14 days' notice. Then we take the money out of escrow, take the $1 million, and then we tell the BOM, branch office manager, Mr. Moran, it's open season on clients and have team members solicit clients. So there is the start down this path of where Alonzo says solicit. Then we go to.
But to be clear, the advice is that it be through others and not her personally.
Right, that is still a breach of the agreement.
Well,
And that was
that's
only-
for us to decide.
Well, that was only the start of it, Your Honor, if I may. So then what happens is, so then they terminate the agreement.
But they also told her, did they not, that this is a hazardous cause of action?
May I continue, Your Honor?
Yes.
There's no evidence of that. See, the total brief is coursing with mendacity. I mean, there are so many misrepresentations in the record of the Alonzo firm, and I would be happy to take the court through just one of them, if I may. So, on page 9 of Mr. Alonzo's reply brief, he says, Mazzone suggests that the AAF defendants approved of direct solicitation by Mazzone, citing the email blasts sent by Mazzone to RBC. And he's referring to our brief, page 23 of our brief. So 2 weeks before the arbitration hearing, my client had a prep session with the Alonzo firm. And she was told in no uncertain terms that if you're asked about these blast emails that you sent out to Schusterman's client, you should say, quote, blast emails were appropriate and not solicitation. And that is consistent with the advice that she was given all along.
Wait.
Consistent with
If that's advice given to explain something that your client did that they didn't suggest she do, that's different advice. That's called cleanup.
correct,
Okay?
right, Your Honor?
So the question is, where in the record does it show that Alonzo advised her, solicit freely, free abandon, you can do it, no problem? Where in the record does it say that?
3859 of the record. After, well, let me take a step back to 3857 and 3858 of the record, where Mazzone seeks advice from Moran about how to speak to Moran. And the advice...
Wait. Seeks advice from whom?
Thank you, Your Honor. Mazzone seeks advice from
From
Mr.
Alonzo?
Mr. Alonzo
Okay.
about how she should speak to Mr. Moran.
Okay.
And Alonzo says, go after the whole book. Go after Schusterman's clients. And then on the next page,
But again,
says-
counsel, I have to stop you. Because it doesn't say, if what you were reading to me said, you go and you solicit yourself, every single client you can get and keep every single one, versus tell your boss, absolutely go after every client you can. Those, to me, those are two different things, because the latter falls into the category of your company can do it, but you shouldn't do it directly.
but there was, all right, so I'm going to take you to the next page, Your Honor. So,
And we're not going to go through every page. So
fine, no.
you have,
all right,
you
Ms.
have,
Owen,
counsel, you're at your red light.
I understand,
So I'm
Your-
going to give you 30 seconds to wrap up.
okay. Mazzone said to Alonzo, I want to send out this letter to all the clients under her name, touting her experience, touting her work with them at RBC. And Alonzo says, okay to send, nicely written. I appreciate that it doesn't solicit for you, even though you can at this point. All it says is for people to continue their relationship with you at RBC. But it was a solicitation. That was one of the key documents that was presented at the arbitration that led the panel to award Schusterman $540,000. We have emails.
Thank you. We have the record. Trust, it's a very lengthy one, and we have, as you can see, painstakingly gone through as much of it as we could before argument. You have 2 minutes, and then we are done.
Thank you, Your Honor. I think you see the point here, that the advice was not to directly solicit. And we presented expert evidence stating that the advice Mr. Alonzo gave was that fit within the mold of Bessemer, to be the passive professional, to allow your company to solicit. And as Mr. Freeman mentions, the Furgang letter was initially to be signed by Ms. Mazzone. Ms. Mazzone consulted with my client, and it was the suggestion of my client that Mr. Moran reach out to all of the clients first. And Ms. Mazzone came back to my client with the letter signed by her, crying that she was going to be fired if she did not send that out, and she needed to send it out as per RBC. And then she had a conversation with Ms. Russo and Mr. Alonso, and they changed the letter to Mr. Fergang's signature because Mr. Moran didn't want Ms. Mazzone to have all those clients on her own anyway. He didn't trust her that she could handle $300 million. She only had $5 million of her own. Moreover, those
The letter
conversations—
that went out was the one that I think was in 4592 of the record. Maybe I'm wrong, but I have a copy of it.
Yes.
That went out from Mr. Fergang.
Correct.
And
The only letter that was
a letter similar to that did not go out from Ms. Mazzone. It went out from Mr. Fergang.
Correct. And that letter didn't go out after the conversations with Russo and Alonso. And while Russo claims that she submitted expert testimony to establish there was no attorney-client relationship, that affidavit from Mr. Wasserman does not address any of the deposition testimony given by Mr. Alonso. It doesn't address that Mr. Alonso said she was on the phone, that Ms. Mazzone dialed her in and they had a three-way call. It doesn't address the fact that Ms. Mazzone testified at arbitration that Ms. Russo was another counsel and questioned whether or not that was Ms. Russo's handwritten edits on the Fergang letter. That testimony was presented, and the attorney-client relationship is a question of fact that cannot be determined on summary judgment, regardless of their expert report, when it doesn't address all the facts that were submitted.
Thank you.
Thank you.
Wait. I think there's another appellant.
Okay.
I'm sorry.
Sorry,
I'll be
messed
quick.
up. Not a problem. Go ahead.
I want to address two things because they're interrelated, and there you go. First, when that came in, as Ms. McAvoy said, she said, they're telling me I have to send this letter. Now we're at August 25th, a month after she's been laying claim, and they have now given her. She said, no, I'm not just going to take the 25% because I don't know which ones would stay, contrary to her statement now. So she goes ahead and says, no, you got to give them all to me. And she's meeting with Moran. But so that she didn't say something wrong, we wrote her a script to tell Mr. Moran, I can't solicit. Somebody else has to. You got to get me someone who can do that. And then she came in, and after she got all the clients—
But that's not what he read from the transcript. What he read from the emails was that you said you got to go all in, go after the team or something.
Well, first of all, let me just say, I had that. That was not, no, let me just start in that time sequence. She came and said, they want me to send this letter, which is the normal, legally required letter that has to go to clients saying somebody left, normally from the branch manager. She said they'd fire me. And then, after that, I said, and this was then taking on the tone of a divorce case with the bitterness and everything, and I said, you have to bring Donna on. My partner, Katanya Thatcher, the one time in 20 years she has dropped the ball in the sense that she's always there. She works nights, weekends. She's there every minute. And she left for a few days because her father died, and I had a client who was distraught, and I got Ms. Russo to say, look, let's talk about this letter. And Ms. Mazzone, Ms. Russo, and I got on the phone. And as it turns out, there were many calls. There's actually a list in the record of everything Ms. Mazzone was involved in Ms. Russo, settlement negotiations and everything. But the one thing that the lower court focused on was the solicitation conversation, that particular conversation. And we know that Ms. Mazzone understood because the letter changed from a Mazzone letter to a Fergang letter. We know it because she testified at the panel. And if she believed we told her she could solicit, when the panel said, are you allowed to solicit? She would have said, yeah, my lawyers told me so. Instead, she said, I didn't solicit. She gave the chairperson, who's the dean of Pace Law School, an explanation, a good one, of what solicitation was, and said she didn't do it. The chairperson noted that wasn't true. And I want to say, I don't have an expert report saying that what Ms. Russo did was wrong because she didn't do anything wrong. We were on that call, and that was the right thing to say. Yeah, now that you're not being fired, because Ms. Mazzone said, oh, well, actually, they're not going to fire me if I don't send a letter, then Ms. Russo opined, yeah, well, then don't send it yourself, which is what I was saying all along. So when that happened,
Thank you.
I realized it's time to thank you and leave.
Okay. I'll give you a minute. I realize my colleague just schooled me. Please.
To clarify a few points that were brought up by counsel. Alonzo Andalcar's counsel brought up for the first time during this argument her argument regarding the attorney-client privilege. That was not briefed in her papers, and I believe that should be disregarded as it's not included. She also points out that our expert report doesn't address Russo's involvement based on Mr. Alonzo's testimony. And that's because Mr. Alonzo didn't testify to it. A lot of these facts regarding Russo's involvement were first brought up in his affirmation on the summary judgment motion. There's also no evidence in the record that Ms. Russo participated in any way with the FINRA arbitration preparation for it. Thank you, Your Honors.
Thank you. Have a good day and a good evening, everyone.
Thank you.
Find someone to check the judge's entrance door.
Lobby, court is over. You have 4 coming out.